This is going to blow your mind. Specifically, what happens to your assets when you're no longer around? Understanding your state's laws is crucial. The U.S. is divided on property rights during marriage. Some states follow community property, others common law. Community property means shared ownership of assets acquired during marriage. Common law states recognize individual ownership. Now, let's be crystal clear about what constitutes marital property versus separate property. In community property states, assets acquired during the marriage are generally considered community property, owned equally by both spouses. This typically includes earnings, real estate purchases, and even debt accumulated during the marriage. But hold on, there are exceptions. Separate property usually includes anything a spouse owned before the marriage, inheritances received individually, or gifts given specifically to one spouse. These assets retain their separate character even after the marriage. Common law states also recognize separate property, often defined similarly to community property states. However, the key difference lies in how marital property is treated. In common law states, assets acquired during the marriage might be considered separate property if they are only in one spouse's name. Why does all of this matter? Because understanding the distinction between community property and common law states is crucial for effective estate planning. Your state's laws can significantly impact how your assets are distributed after you're gone, especially if you don't have a will or trust in place. In community property states, each spouse has the right to dispose of their half of the community property. However, they generally cannot unilaterally dictate what happens to the other spouse's share. This is where estate planning tools like wills and trusts become invaluable, allowing you to express your wishes and ensure your assets are distributed according to your desires. Common law states offer more flexibility in some ways. Since assets are often individually owned, spouses have more control over their disposition. However, this also means that without proper estate planning, your assets might not automatically transfer to your spouse as you might assume. Let's talk about the cornerstones of estate planning, wills and trusts. These legal documents are your voice beyond the grave, ensuring your wishes are honored and your loved ones are taken care of. A will is a legal document that outlines how you want your assets distributed after your passing. It also allows you to name guardians for minor children and designate an executor to manage your estate. Without a will, your state's intestacy laws will determine the distribution of your assets, which might not align with your wishes. A trust, on the other hand, is a legal entity that holds and manages assets for the benefit of designated beneficiaries. Trusts offer several advantages, including potential tax benefits, probate avoidance, and greater control over asset distribution. Section 5, Estate Planning in Community Property States, a step-by-step guide. If you reside in a community property state, here's a simplified roadmap for your estate planning journey. First, inventory your assets. Make a comprehensive list of all your assets, clearly identifying separate and community property. Next, initiate open communication. Discuss your estate planning goals and wishes with your spouse. Open communication is key to ensuring you're on the same page. Then, consult an estate planning attorney. Seek guidance from an experienced estate planning attorney licensed in your state. They can help you navigate the nuances of community property laws and draft a plan tailored to your needs. After that, draft a will or trust. Your attorney will help you create legally sound documents that reflect your wishes and comply with your state's laws. Finally, review and update regularly. Life is dynamic, and so are your assets and family structure. Review and update your estate plan regularly, especially after major life events like marriage, divorce, birth, or death. Section 6, Illustrating Community Property Principles. The case of John and Mary. Let's meet John and Mary, a fictional couple residing in California, a community property state. They've been married for 10 years and have accumulated a comfortable life together. John, a software engineer, earns a substantial income, while Mary, a talented artist, is a stay-at-home mom to their 2 young children. During their marriage, they purchased a beautiful home, invested in a diversified portfolio, and diligently saved for their children's education. Under California's community property laws, all these assets are considered community property, owned equally by John and Mary, even though John is the primary breadwinner. Imagine tragically, John passes away unexpectedly. Without a will, California's intestacy laws would dictate that Mary inherits all community property. However, without a will, John's wishes regarding specific assets or guardianship of their children might not be carried out as he desired. This scenario highlights the importance of having a comprehensive estate plan, even in community property states. Section 7. Estate planning in common law states. Charting your course. Navigating estate planning in a common law state requires a slightly different approach. Here's a step-by-step guide to help you get started. First, identify and categorize assets. Begin by listing all your assets and categorize them as separate or marital property. Remember, in common law states, individual ownership often takes precedence. Next, open the lines of communication. Just like in community property states, discuss your estate planning goals and wishes with your spouse. Transparency and understanding are crucial. Then seek professional guidance. Consult an experienced estate planning attorney licensed in your state. They will guide you through the intricacies of common law principles and help you develop a plan that aligns with your goals. After that, craft your will or trust. Your attorney will draft legally sound documents ensuring your assets are distributed according to your wishes while adhering to your state's laws. Finally, regular review and updates. Life is full of surprises, so it's essential to review and update your estate plan periodically, especially after significant life events or changes in your financial situation. Section 8. Spotlight on Common Law, the story of David and Emily. Let's travel to New York, a common law state, and meet David and Emily, a couple married for 8 years. David, a successful entrepreneur, founded a thriving tech startup before their marriage. Emily, a talented architect, runs her own firm. During their marriage, they purchased a spacious apartment in Manhattan and invested in various assets. However, they maintained separate bank accounts and managed their finances independently. Under New York's common law system, the apartment, purchased jointly, would likely be considered marital property. However, their individual businesses, established before the marriage, would remain separate property. Suppose David wants to ensure that Emily inherits his share of their apartment and receives a portion of his business assets upon his passing. In that case, he needs a well-drafted will to explicitly state his wishes. Without a will, New York's intestacy laws might distribute his assets differently, potentially leaving Emily with less than he intended. Section 9. Seeking expert guidance. Your compass in estate planning. Estate planning, regardless of where you live, can feel overwhelming. The legal jargon, the complexities of property laws, and the emotional weight of planning for the unknown can be daunting. But here's the good news. You don't have to navigate this alone. Seeking guidance from an experienced estate planning attorney is not an indulgence. It's a necessity. Consider it an investment in your peace of mind and the financial well-being of your loved ones. An estate planning attorney will explain the nuances of your state's property laws, whether community property or common law, help you understand the different estate planning tools available, such as wills, trusts, and powers of attorney, guide you through the process of creating a comprehensive estate plan that reflects your wishes and complies with legal requirements. Answer your questions and address your concerns, providing clarity and confidence in your decisions. Section 10. The crucial role of communication and legal counsel. Estate planning is not a solitary endeavor. Open and honest communication with your spouse or partner is paramount. Discuss your individual goals, shared aspirations, and any concerns you might have. Remember, you're in this together. Once you've established a foundation of open communication, seeking professional legal counsel is the next crucial step. An experienced estate planning attorney will be your guide, advocate, and translator, helping you navigate the complexities of estate planning laws and ensuring your wishes are legally documented. Section 11. Conclusion. Securing your future through informed estate planning. Understanding the differences between community property and common law states is not just about legal technicalities. It's about taking control of your financial legacy and ensuring your hard-earned assets are protected and distributed according to your wishes. Whether you're just starting your estate planning journey or need to update existing documents, remember that knowledge is power. By understanding the laws of your state and seeking expert guidance, you're taking a proactive step toward securing your future and providing for your loved ones. Don't wait for a life-altering event to force your hand. Take charge of your estate planning today and face the future with confidence, knowing you've taken steps to protect what matters most.